The prosecutor laughed out loud in the middle of the courtroom. He turned to the jury, spread his arms wide, and said the words that would destroy his career. "Your Honor, with all due respect, we are wasting taxpayer money listening to a janitor pretend to understand the law. Let him mop the floors, let us handle the statutes." The gallery chuckled. A few reporters smirked. The judge did not stop him. And the man in the witness box, a 58-year-old black janitor named Elijah Monroe, simply folded his hands and waited. He did not flinch. He did not look down. Because Elijah Monroe was about to do something no one in that courtroom expected. He was about to recite, from memory, the exact federal statute the prosecutor had just misquoted, followed by 3 Supreme Court cases that overturned it, with majority opinions, dissents, and page numbers. The prosecutor's smile would die within 90 seconds. The judge would lean back in stunned silence. And before the hour was over, the entire case would collapse. It was a cold Tuesday morning in March when Elijah Monroe walked into the Fulton County Superior Courthouse in Atlanta. He wore his navy blue janitor's uniform, the same one he had worn for 11 years. His name was stitched above the left pocket. His shoes were polished because his mother had taught him that a man's shoes tell the world how he feels about himself. He was 58. His hair had gone gray at the temples. His hands were weathered, calloused. He carried a small brown paper bag with a tuna sandwich, an apple, and a thermos of black coffee. He nodded at the security guards who knew him by name. But instead of going to the supply closet like every other morning, he walked into courtroom 4 billion. He was not there to clean. A subpoena had been delivered to his apartment the night before, commanding him to appear as a witness in the trial of Marcus Dupree. A 22-year-old Elijah had known since Marcus was in diapers. Marcus had grown up in the same apartment building. His father had died in a construction accident when Marcus was 6. His mother worked 2 jobs. Despite everything, Marcus had earned a full academic scholarship to Morehouse College. But 3 weeks earlier, Marcus had been arrested and charged with armed robbery of a convenience store. The security footage was grainy. The suspect wore a mask. The cashier's identification had been shaky. Marcus had been home studying for a calculus exam. And Elijah Monroe was the only person who could prove it, because he had seen Marcus walking home from the library at exactly the time the robbery was happening, 3 miles across town. The lead prosecutor was Bradford Whitlock III. He was 38, tall, with sandy blonde hair combed straight back. His father was a former state senator. His grandfather had been a federal judge. He had graduated magna cum laude from Duke Law School. He had never lost a felony case, and he was being courted by the state Republican Party to run for district attorney. To Whitlock, Marcus Dupree was not a person. He was a stepping stone. When Whitlock had seen the witness list the night before listing Elijah Monroe as occupation, janitor, he had laughed in his office. He told his paralegal, a janitor alibi witness. We are going to eat him alive on cross. He had no idea that the man he was about to mock had once held a secret that could have ended his grandfather's career. The courtroom was only a third full. A few retirees, 2 reporters. Marcus Dupree's mother sat in the front row, hands clenched so tight her knuckles had gone white. The judge was the Honorable Randall Pierce, a 62-year-old former corporate attorney. He was known for running an efficient courtroom and rarely interrupting prosecutors. He and Whitlock had played golf together twice. The defense attorney was Sheila Ramirez, 34, 3 years out of law school, overworked, carrying 47 active clients. She had met Marcus for only 40 minutes before the trial began. She believed he was innocent, but the deck was stacked against her. When she called Elijah Monroe to the stand, she did so with quiet hope and very low expectations. Elijah walked up slowly. He raised his right hand. He was sworn in. Sheila walked him through the basics: his name, his age, his occupation, how long he had known Marcus. Then she asked where he had been on the night of February 14th. Between 9 o'clock and 10 o'clock p.m., Elijah answered calmly. He had been walking home from the corner store. He had seen Marcus walking toward the apartment building, carrying a backpack full of textbooks. They had waved. They had talked about Marcus's calculus exam. The time was 9:47 p.m. Elijah remembered because he had looked at his watch, a watch his late wife had given him on their 20th anniversary before she died of ovarian cancer in 2019. It was clean, believable testimony. Sheila sat down and Bradford Whitlock stood up. He did not go after the testimony. He went after the man. "Mr. Monroe, you clean buildings for a living, is that correct?" "Yes, sir." "And how far did you get in school, Mr. Monroe?" Sheila objected. The judge overruled her. I finished 11th grade, sir. Whitlock smiled and turned to the jury. 11th grade, no college, no law school, no formal training of any kind. You are, if I understand correctly, someone who spends his days mopping floors and emptying trash cans. Sheila objected again. The judge told Whitlock to get to his point. Then Whitlock delivered the line that would end his career. He turned to Judge Pierce, spread his arms wide, and said, Your Honor, with all due respect, we are wasting taxpayer money listening to a janitor pretend to understand the law. Let him mop the floors. Let us handle the statutes. A ripple of laughter moved through the gallery. The judge did not call him out of order. Elijah Monroe sat very still. He did not frown. He did not speak. Then he said, May I respond, Your Honor? Judge Pierce nodded. Briefly, Mr. Monroe. Elijah leaned forward. His voice was calm, steady, and deep. Mr. Whitlock just cited Georgia Code Section 24-6-620 regarding witness credibility. I would like to respectfully point out that he has misrepresented its application. That statute governs the impeachment of a witness based on prior inconsistent statements, not based on the witness's profession or educational background. Using profession as a basis for impeachment violates Rule 610 of the Federal Rules of Evidence, and was explicitly rejected by the Supreme Court in United States v. Abel 1984, 469 U.S. 45. The court held, in the majority opinion written by Chief Justice Rehnquist, that bias impeachment is permissible, but class-based impeachment is not. Mr. Whitlock has just attempted in open court to impeach a witness based on class, which is reversible error on appeal. The courtroom went silent. Whitlock's smile froze. The reporters stopped writing. Judge Pierce slowly lifted his head from his papers. Marcus Dupree turned and looked at Elijah with absolute wonder. Whitlock tried to recover with a nervous laugh. Well, Your Honor, it seems our janitor has memorized a few legal phrases. Impressive for a man of his background. And that was when Elijah Monroe did something no one was prepared for. He kept going. Mr. Whitlock, since you brought up the question of my qualifications, I would like to clarify something for the record. Judge Pierce, now leaning forward with both hands flat on his desk, said, Go on. You mentioned my testimony might be unreliable because I lack formal legal training. I would like to draw the court's attention to Rock v. Arkansas, 1987, 483 U.S. 44, in which the Supreme Court held that a state cannot arbitrarily exclude a witness's testimony based on a per se rule. Justice O'Connor wrote the majority opinion. The courtroom was so silent you could hear the ventilation system humming. Elijah continued. Mr. Whitlock, you also argued in your opening statement 3 days ago that the defendant fits what you called a behavioral profile consistent with armed robbery. That language invokes character evidence, which is generally inadmissible under Rule 404A of the Federal Rules of Evidence. The only exception is when the defendant himself introduces evidence of his own character, which the defense has not done. Therefore, every reference you have made to the defendant's behavioral profile is improper character evidence, and the jury should have been instructed to disregard it. That instruction was not given. That is reversible error. He paused. Then he did the thing that broke the courtroom open. Furthermore, the state's identification of the defendant by the cashier was based on a photo lineup that, according to the discovery material I reviewed last night, contained 6 photographs, 5 of which were of men with noticeably lighter skin tones than the defendant. That is a suggestive identification procedure under Manson v. Brathwaite, 1977, 432 U.S. 98, and it should have been suppressed at a pretrial hearing. That hearing never happened. He looked directly at Whitlock. I am not a lawyer, Mr. Whitlock. I clean buildings for a living, but I can read. And what I read in those documents last night was a violation of this young man's constitutional rights under the 5th, 6th, and 14th Amendments. Whitlock opened his mouth. No sound came out. He managed, Your Honor, I move to strike the witnesses, but he did not finish. Judge Pierce held up one hand. He had quietly closed the case file on his desk. He was looking at Elijah with an expression that Sheila Ramirez would later describe as the look of a man who had just realized he had been presiding over something very wrong for a very long time. Mr. Monroe, the judge said, his voice no longer the voice of a man running an efficient courtroom, but the voice of a man genuinely wanting an answer. How do you know all of this? Elijah looked at the judge, at the jury, at Marcus's mother, now crying silently, and finally at Whitlock, still standing with his mouth open. Your Honor, before I answer, I would like to say one more thing. Mr. Whitlock asked me whether I was qualified to make precise time-based observations. I would like to answer now. In 1991, I graduated summa cum laude from Howard University School of Law. In 1992, I passed the bar exam in Georgia on my first attempt, with one of the highest scores in the state that year. From 1992 to 1995, I worked as an assistant public defender in Fulton County, representing indigent clients in felony cases. In 1995, I took a capital case in which my client was accused of murdering a white police officer. My client was innocent. I proved he was innocent. But during that trial, certain things happened to me and to my family that I do not wish to speak about in open court. I left the practice of law in 1996. His voice trembled slightly. I took a job as a janitor because I needed work that would not require me to speak in courtrooms. I took it for my wife, who was sick, and for my son, who needed a father who came home every night. My wife passed in 2019. My son is a lieutenant in the United States Air Force. I have been cleaning buildings for 29 years, Your Honor, but I have not forgotten a single thing I learned. I read the advance sheets every week. I study the opinions. I teach the law for free on Saturday mornings to young people in my neighborhood who cannot afford tutors. I was subpoenaed in this case as an alibi witness. I came here to tell the truth about where Marcus Dupree was on the night of February 14th. But Mr. Whitlock asked me whether I was qualified, and the answer is yes. I am qualified. I am more qualified than he is, and I am watching him violate this young man's rights in front of a jury that does not know any better. The courtroom exploded. 2 reporters bolted for the door. The gallery erupted in whispers. Judge Pierce banged his gavel once and said, "This court will take a 30-minute recess. Mr. Whitlock, I want to see you in my chambers." Now, what happened in the judge's chambers was not recorded, but the consequences were impossible to hide. When court resumed 45 minutes later, Whitlock's face was ashen. In a voice barely audible, he announced that the state was moving to dismiss all charges against Marcus Dupree with prejudice. Judge Pierce accepted the motion immediately. Marcus Dupree walked out a free man. His mother fell to her knees and wept. Marcus crossed the courtroom, walked past his own attorney, walked past the prosecutor, and went straight to the witness box. He took Elijah's hand in both of his own and cried. Elijah put his other hand on the back of Marcus's neck, the way a father does with a son, and whispered something only Marcus could hear. Years later, Marcus would say it was the single most important sentence anyone had ever said to him. Bradford Whitlock III was suspended within 48 hours. An investigation was opened, and it expanded to cover a dozen other cases. It was discovered that he had a pattern of class-based and race-coded impeachment tactics, that he had withheld exculpatory evidence in at least 3 cases, and that 2 innocent men were serving prison sentences because of his misconduct. Both were released within a year. Whitlock was disbarred in 2026. His political career was over. His father stopped returning his calls. Judge Randall Pierce took early retirement 6 months later. He told the press that after 38 years in the legal profession, he had realized he had stopped listening to people whose appearances did not match his expectations. He began volunteering at a legal aid clinic. The first person he called for a recommendation letter was Elijah Monroe. Sheila Ramirez received a call the week after the trial from a partner at one of the largest civil rights law firms in the country. She took the position but still takes 3 pro bono court-appointed cases per year. She says Elijah Monroe taught her that talent hides in the most unexpected places. Marcus Dupree started at Morehouse that fall. He graduated with a double major in political science and philosophy. He is now a second-year student at Howard University School of Law, the same school Elijah graduated from in 1991. He plans to become a public defender. When reporters ask why, he always says, "Because there is a 13-year-old kid out there right now who is about to be arrested for something he did not do, and when he walks into that courtroom, I want him to have a lawyer who looks at him and sees a person." Elijah Monroe went back to work the next morning. He put on his navy blue uniform. He polished his shoes. He took the service elevator to the 4th floor, but the supply closet door was locked. A note was taped to it. As of that morning, Elijah Monroe was no longer employed as a janitor. The dean of Emory University School of Law had called the administrator's office the evening before. Emory was offering Elijah Monroe a full-time position as a distinguished visiting professor of constitutional law, with a full salary, a private office, and the freedom to teach whatever courses he wished. The dean had written, We have been looking for a professor of your caliber for 30 years. It turns out you were cleaning our rivals' hallways the whole time. Please come home." Elijah stood in that hallway for a long time, holding the note. He thought about his wife. He thought about his son stationed in Germany. He thought about Marcus Dupree and about all the other young people who had been sitting at his kitchen table on Saturday mornings for 29 years, learning the law from a man they thought was just a janitor. He folded the note, put it in his pocket, and walked out into the cold Atlanta sunlight. He accepted the position the following Monday. He taught his first class 3 weeks later to a lecture hall of 240 students. The title of his first lecture was, "On the Dignity of the Witness, Why Every Voice in the Courtroom Matters." Marcus Dupree had driven down from Howard for the occasion and sat in the front row. When Elijah walked to the podium, the entire hall stood and gave him a standing ovation that lasted more than 4 minutes. Elijah Monroe, 58 years old, in a simple gray suit with polished shoes, stood at that podium with tears streaming down his face. When the applause finally faded, he adjusted the microphone, smiled, and said the same thing his mother had told him when he was 6 years old. "Good morning. Let us begin." Elijah Monroe walked into that courtroom carrying a brown paper bag with a tuna sandwich, an apple, and a thermos of black coffee. He walked out carrying the future of a young man, the collapse of a corrupt prosecutor, and the return of a life he had buried for 29 years. He did not raise his voice once. He did not insult anyone. He simply spoke the truth, calmly, precisely, and with a dignity that no uniform could hide and no mockery could break.